that power which you say was in the executive branch and that has now been taken away. Is this, if I've understood you correctly, that power was of what I may call a passive nature. In other words, the President, Governor General could not have initiated rule or exercised rule-making power. It was simply you, Supreme Court, make the rules, but they've got to pass muster with the executive branch before they come into effect. So if this is the analogy that you are drawing, then why ought not the law-making power that you say vests in Parliament in terms of the word law, why should that also not, although it remains there, and as you say, it has never ever been exercised prior to being provisions, but simply something that Supreme Court has to keep in mind when making rules.
Understood, sir. Barring Government of India Act, all other subsequent constitutional frameworks, constitutions that we have had, there was always legislative power. There were always, the rules were always subject to law and constitution.
Our 56 constitution.
56 constitution, in fact, went a step ahead.
Uski language farak hai.
Ji, 170 said that until an act of parliament is made in this behalf.
That's a different language.
So it was actually, it went a step further.
After, what happens after?
And then subsequently 62 and 72, it says subject to the constitution and the law with the prior approval of the president. So what is happening here is, and barring Government of India
Government of India Act.
Government of India Act was totally prior approval in his discretion, and that's about it.
No, but Government of India did not have any legislative engagement at all.
Yes.
So what I'm saying is, if you look at it in the historical context, and I'm now focusing on the analogy that you're making, that previously there was the executive plus the legislative. The executive was purely passive as far as I can understand. So why should not, on that analogy, the law-making power or the law part of it also be regarded not as an enabling power, as a whatever restrictive, limiting power, or whatever, in whatever sense?
One reason perhaps could be that till 1972 or when the 1956 rules were made, because there was a prior approval of the president already there, the legislature chose, and in fact, in 1956, because third schedule applied, until such time it applied when the parliament actually made these regulations to the exclusion of, in fact, the Supreme Court. The 1956 constitution, it did not. So there was, the parliament chose not to act. What I'm submitting, my lords, is that Parliament's choosing not to act or choosing not to act does not, or it cannot be inferred that the Parliament has given up its right.
No, but on the analogy that you make, then the fact that Parliament since 1973 did not choose to act, well, you can go back to 1962, I guess. Certainly since 1973 it did not choose to act, perhaps is not an indication that Parliament has given up anything, but is an indication that Parliament has recognized that this is not an enabling power.
My lord, that would then giving a meaning to,
and therefore there was nothing for Parliament.
And that is why I had referred to Articles 4, 20, 22, and 28 to submit that the term law, or in 19A when it is
there, Mr. Attorney General, the use of the word law over there, I think, has to be read with Section 8. Because Section 8, Clause 1 is the controlling section which says the state shall make no law. Right?
Article 8.
Article 8. Shall not make any law which violates them. And then when you look at the fundamental rights and where it says subject to law, that takes color from as an exception to what is prohibited by Article 8, Clause 1. So that's perhaps, I mean, I'm putting this question to you, that the analogy that you seek to draw from use of subject to law and fundamental rights perhaps is not correct, because the context over there is totally different.
My lord, if I may, now Section 8, Article 8, Clause 2 places a barrier on the state to not make laws which in any way abridges these rights. But what in turn Article 14, this language in Article 14, 20, 22 and 28 is doing is it is actually enabling the Parliament.
Therefore, actually restricting.
No, restriction is there in under clause 2 of Article
यही
8.
मैं बात कर रहा हूँ कि therefore
Restriction is there and here it is enabling.
the reason why it is enabling is because it seeks to balance the overarching restriction imposed in clause 2 or 1 of Article 8. But that is not the position over here in Article 191. So the analogy that you seek to draw, or the assistance that you seek to draw from the use of this phrase in those fundamental rights, perhaps is not correct. What would you say to that?
My lord, the language in clause 2 of Article 8, when read with what is provided in Article 14, and if I may just now read it out.
पहले clause, kindly
Clause 2 of Article 8. It says that state shall not make any law which takes away or abridges the right so conferred. And then, so this is a broader constitutional statement, a requirement that no laws which abridge those rights,
Apparently blanket prohibition.
blanket provision. But the carve-outs in section Article 14 there.
So that the carve-outs therefore are to enable. This is
Yes.
this is you
Yes.
cannot do it at all. So that may be then regarded as enabling.
Yes.
But even over there, it is not to destroy. It is
No, that has to wait. This has to wait whether the destruction part has come into force or not, but this has to wait.
But 191.
When
is
I come to independence of judiciary, this has to wait.
My question still stands. 191 is totally different.
No.
What analogy do you, what assistance do you draw from subject to law?
Exactly
using-
what my lord has just pointed out. It is enabling provision.
No, but it is
In enabling and in the context. Now, in the context of what you just said.
उसका काउंटर फिर क्या है ना, देखिए जो सब्जेक्ट टू लॉ फंडामेंटल राइट्स में इस्तेमाल हो रहे हैं, दे काउंटर बैलेंस आर्टिकल 8.
Yes.
ठीक है?
And Article 191's
191
counterbalances independence of judiciary.
Sorry?
Article 191's counterbalances independence of judiciary.
So the
That
independence.
no law which affects independence of judiciary, and that is why I had
This is your
submitted, please
submission.
wait for this submission on independence of judiciary. That might just answer what you just pointed out.
See, if you are saying the counterbalances the independence of the judiciary, that is the entire argument here.
So इसीलिए उस पे जरा
That
वेट
this
कर लें कि मैं जब उस पे
legislation
सबमिशन करता हूँ तो that might just
एक
address it.
बात तो ये है कि this legislation affects independence of judiciary.
But मैं ये
And
इस पे
if-
अभी आपकी
if
observation.
it comes to, we come to the conclusion that that it does, then obviously the restriction that 191 places is correctly placed, number one. Number two, the word law appears in the Constitution more than 200 times.
Yes.
Now, are you arguing that wherever the word law is used, it is used only in one sense, and that is an enabling sense? Or is it more accurate to say anywhere where it is used, like you have just read Article 8.2 and 14 and 20 and 24, it has to be read in that context. It's one size fits all नहीं है.
As I submitted,
हर जगह जहाँ लफ्ज़ law लिखा हुआ है, उसका एक ही मतलब नहीं है. You have to contextualize
मैंने
it.
at the outset, when I said that law's two sources, which is this positive law and act of parliament and the judge-made law, so these are broadly two sources of law which the constitution recognizes, which our jurisprudence recognizes. So these are the two sources which we will apply whenever the term law appears, and then see which of the sources fits it. Now let's turn to Article 192.1 and compare it with Article 176.
Before going to that article,
Mr. AG,
you are talking about
the
Article
purpose?
8 of the, Mr. AG, please, you are talking about Article 8 of the Constitution,
first hear
which is
Mr. Mendu,
in
please.
chapter number 1, which speaks about fundamental rights. See, subclause 2 of Article 8 says, which takes away or abridges the right so conferred. Which right this article is talking about?
The fundamental rights, my lord, in the chapter.
So the
Article
law
9 through.
Any law should not be in contravention or should not take away the fundamental right of the.
Yes, so my submission
So
was
whether-
that this is the broader restriction which the Constitution places and then enables under Articles 14, 22 to then subject those rights to the laws which may be made in.
Here question for you is that the law which is promulgated, present law, this takes away the fundamental right of a people of independence of judiciary and their to secure their right through independence of the judiciary. This is the question whether it takes away or it not takes.
So that is why I had submitted that when I address the independence of judiciary and also separation of powers, both concepts sort of intertwined in the constitutional sense, so that this question might be adequately addressed at that time, and that is the barrier. Now, if my lords may kindly turn to quickly to 176 first, Article 176 first, my lord.
I just want to ask, because for last 5 days there is a confusion, the using of word law in Article 191. Then if it is used, then what is the purpose?
Yes.
What is the purpose of using this word? Why not only constitution?
Yes, yes. Now,
And learned Attorney General, it is not just law, it is subject to law. So that is what is more important.
absolutely, I'm coming to it, my lord. First, Article 176, need not take you lordship through it. This is about the number of judges. Now, it says that the Supreme Court shall consist of the Chief Justice and the judges as determined by an Act of Parliament. So the term used is Act of Parliament. Now, if my lords may kindly turn to Article 192, Clause 1, which is in relation to high courts. Here it says,
Which one?
192, Clause 1. Here it says the High Court shall consist of Chief Justice and so many judges as determined by law. Now, in these two provisions, there are two different terms which have been used, but what are we to make of this term law used here? To my mind, it can only be an Act of Parliament. It perhaps can't have that other source read into it that if the, let's say, the Supreme Court gives a judgment.
You are saying it means the same thing or they means different things?
My lord, in my respectful submission, in the context of Article 192(1), the term law is to be treated as
But why
an
can't
act.
it, why can't, no, but why can't it mean Act of Provincial Assembly?
It could be.
No, it's a, this
It is. I thought about it. I thought about it. But then the problem is that the Constitution, because under entry 55, when it is jurisdiction and powers of all courts, and in that context,
that's the concurrent list, where the provincial assemblies, you see, the problem of saying what you are saying is in relation to 192, law means Act of Parliament, is that it then relates to entry 58. And entry 58 says anything which is in the competence of Parliament or relates to the Federation
Yes.
is exclusively in the federal domain. Provinces can't make any law. Now, surely a province is entitled to say, well, sir,
we need more judges.
no, we need more judges. That a high court, it may be a matter relating to the federation, but it also relates to a province. How can you relate law over there as Act of Parliament, read it with entry 58 and just wipe us out of the picture? No, but वकील साहब,
मैं इस पे आगे आने लगा हूँ ना।
अटॉर्नी जनरल साहब, इसमें एक मुश्किलात है ना। अब सवाल ये उठेगा, अगर दोनों हैं तो फिर कंकरेंस है तो फिर पैरामाउंसी है। देखिए, जो क्वेश्चन दैट माय बात सुन लें, द क्वेश्चन दैट माय लर्नेड कॉलीग पुट टू यू, वन साइज फिट्स ऑल नहीं चल सकता यहाँ पे। यूज ऑफ द वर्ड लॉ कैन हैव सो मेनी शेड्स ऑफ मीनिंग। तो आप जरा
इसको हम एड्रेस कर लेते हैं। इसको इट्स इजीली एड्रेस
करने की जरूरत नहीं है, लेकिन आई एम जस्ट पॉइंटिंग आउट द
No,
डिफिकल्टी।
I thought about it that why can't mean an act of provincial assembly, but that need not detain us for the purpose of Article 191 because there the Supreme Court is exclusively
There's no doubt
outside
about
of
that,
that.
yes.
So therefore, for the purposes of 191, there is a confusion here. I thought about it, but then I stopped thinking about it for that matter because 191 के लिए relevant नहीं था.
नहीं, but
But in any way, in any event, it would be an act of parliament or
नहीं, but why don't you say it is intentional by the framers of the Constitution that one place it is by Act of Parliament, surely there it could not be by law. So we are agreed there, I hope. And the other one, the Parliament kept the door open, whether it would be Parliament itself or it would be the Provincial Assembly, without fixing it, because maybe the framers of the Constitution wanted to make the Constitution a living, breathing organism which can, depending on the situation at that relevant time, they have put Act of Parliament then it would have fixed it and provincial assembly would have gone away. Or if they have put parliament or provincial assembly, they may not have wanted to do so. So sometimes ambiguity is intentional. It is not that they made a mistake or didn't think about it. I would consider that if they use the word law there, we don't need to address that in this case, but it is the only thing which comes out clearly is that the first one is fixed by the parliament and the other one by law, which could surely not include judge-made law.
And it
I mean,
surely-
I would think that would be a stretch if we say, no, it could also include judge-made law.
And
I don't know.
If I may, it should surely be an act. We can debate which assembly or the parliament that we can park it aside for the purposes of these proceedings. But what it surely does is that for purposes of Article 191, an act of parliament cannot be
So it's the
excluded.
context
That's
which
a
has to be
starting
seen.
point,
The
yeah.
context is
cannot
relevant. I think the language is used in context. The words should not, don't mean, the same words can mean very different things used in different contexts.
Yes. The point that I'm trying to make through
So the
this is
starting
that an
point
act
is-
of parliament is included, is covered in the meaning of
That's
term
the
law in
starting point,
191.
yeah, that's- yes.
191. Now, before I,
Attorney General, you were just referring to 192 and you said the word law is used here, but देखें उसका context क्या है? The High Court shall consist of a Chief Justice and so many judges as may be determined by law. ठीक है? अच्छा अब उसको आगे क्या उन्होंने क्वालिफाई कैसे किया? Until so determined. इसमें क्लियरली इंटेंशन है कि जी लेजिस्लेटिव कॉम्पिटेंस वो दे रहे हैं कि आप जब तक वो लॉ नहीं बनाते तो प्रेसिडेंट डिटरमिन करें. There is no such phraseology used in 191. It doesn't say until such law is made.
there is a reason for that.
Yes.
The reason is because in both 1962 and 72, the identical language appeared. And when 93 constitution commenced, we already had the rules. So there was no reason for anyone to determine anything because there was already something in existence.
So obviously
Unlike this
इसमें
situation
ये
perhaps.
कहा जा सकता था ना अगर ये इंटेंशन थी कि जी the Supreme Court may make rules regarding regulation of procedure and practice until law is made or a law is promulgated. ठीक है? उसमें लेजिस्लेटिव कॉम्पिटेंस कन्फर कर रहे होते कि जी सुप्रीम कोर्ट अगर रूल्स बना भी लेती है तो आप अगर कानून बना देते हैं तो इट वुड ओवरराइड दोज रूल्स. Now that intention is neither explicit nor implicit in the language of 191.
My lord, my respectful submission is that it is not so.
जहाँ उनकी इंटेंशन थी कि जी लेजिस्लेटिव कॉम्पिटेंस ग्रांट करने की वहाँ लेजिस्लेटिव कॉम्पिटेंस एक्सप्रेसली ग्रांट की है.
My lord, I'm going to come to that, but let me first address the question that you had previously raised, and let me just deal with it because when we look at the term law, we have to give it some meaning. Some meaning to it. I have submitted that there could be two meanings to it. One meaning is an act, other meaning is a binding precedent. I'm going to deal with it when I address the question of convention. But let me first take care of the 1956 rules being existing law and then proceed with it.
Do you have attached the rule 1956 in your paper book, 1956 rules?
My lord, this may kindly be recorded, my lord. This is something that I thought about later, so this may kindly be noted. Now, 7 of Article 268 does include within its meaning rules, bylaws, regulations as existing laws. And then clause 1 of Article 268 tells us how they shall be dealt with under the new constitution. I'll just read out 268 clause 1 and then take your lordships back to 191 and then the rules of 1980. Clause 1 of Article 268, it says, except as provided by this article, all existing laws shall, subject to the Constitution, continue in force so far as applicable and with necessary adaptations until altered, repealed, or amended by the appropriate legislature. identical language in 270AA6, which deals with anything and everything that had happened prior to omission of or concurrent legislative list
Sorry,
after the 18th
I'm not
Amendment.
following it. Are you saying that Article 268(1)
Ji.
saves laws which are,
And
existing laws which it goes on to define in subclause 7, but specifically excludes decisions of the Supreme Court or the High Court? Are you saying that?
No, what I'm saying
This
is,
definition of law does not say and decisions.
मैं अभी उस पे आता हूँ सर, मैं यहाँ पे ये कह रहा हूँ कि जो existing laws थे, उनको save किया.
Yeah, but when
Granted.
we're using the term law, because sometimes you say it includes decisions. So, but this article does not
This is
mention.
independent of my earlier submission. मैं यहाँ पे उस point को address कर रहा हूँ जहाँ पे my lord की observation थी
नहीं
Justice
वो
Ijaz की.
मैं वो बातें नहीं मैं आपसे सवाल
वो
स्टैंडर्ड
तो नहीं
सवाल
होगा।
कर रहा हूँ मैं ये कह रहा हूँ कि does this mean that this is the starting point and we are not, the courts are free of earlier judgments because existing laws does not specifically mention decisions of the superior courts or of any courts?
उसमें my lord perhaps 189 का effect
No, perhaps
आएगा.
नहीं मगर
189 का
अगर आपका
effect
लॉ
so long
आप
as
उसको एक्सटेंडेड मीनिंग दे रहे हैं तो यहाँ आप उसको रिस्ट्रिक्टेड मीनिंग दे रहे हैं
provisions which survive will
Existing
have to
laws
be
की
read.
definition
हाँ?
दी हुई है AG साहब.
The provisions
Existing
which
laws की
Clause
definition.
7.
जजमेंट्स का तस्करा नहीं आ रहा है ना
नहीं आ रहा ना, वो 7 में definition
उसमें-
पढ़ लीजिए
उसमें ये
आप.
होगा definition.
Existing laws की
जी
sub article 7 पढ़ लें.
जी.
In this article, existing laws means
All laws including ordinances, orders in council, orders, rules, bylaws, regulations and letters patent
शायद इसलिए भी
constituting
ना
a high
कि
court and any
Mr.
notification.
Attorney General, this is a saving clause, so they could not have referred to the judgments. It is a saving clause, could only deal with laws.
Laws and so long as the
Ordinances.
laws continue the effects of the
why are we
judgment
why are we
continues.
categorizing it as a saving clause?
My lord,
No, tell me from the text why are you categorizing it as a saving clause?
my lord, giving continuance to the laws which were in field.
No, but
because
if you read it with subclause 1,
Ji.
it is nothing saving about it.
no, what it is doing is, it is in order to ensure the continuity of system. It is
Part of the
permitting those laws to
देखिए, if that
continue
is the
till such
argument,
time.
if that is the argument, then continuity of the system surely requires judgments to be sustained as well.
मैं उसकी जरा थोड़ी सी ये submission complete करूँ, ये confusion.
Okay.
Let me just complete my submission. My lord, my submission, and then let me just now state what my submission is before I come to explaining it. My submission is that the term law used in 191 cannot possibly include 1956 rules. And I say this because if
Existing laws did not include.
the term law in 191 used in Article 199 cannot include 1956 rules, because this is the observation, this is an observation made by my Lord Justice.
Kindly repeat that, I'm missing it.
The
1956
term law used in Article 191 does not include
1956.
an existing law, which is to say the rules of 1956, the Supreme Court rules of 1956.
Does not include 1956
rules.
Why?
Why? Now, if we turn to clause 1 of Article 268, and if I may reread it,
Before going to that, if you read Article 75, Article 75, please read that, that is, I think it is relevant. And specifically sub-article 3. Yeah, देख ले इसमें, what is law? It has been
law
defined.
को वो कह रहा है कि जब वो एक्ट
आप पढ़ लेगा ना?
जी जी मैं उस
Oh, this,
मैं आ जाऊंगा।
under sub-article 3, it is stated when the president has assented to, it is deemed to a bill, it shall become law and be called an act of
Parliament.
Majlis
Yes.
So, if it is assented by president, the law is an act of the parliament.
मैं सिर्फ ये तो मैं ऐसी एट आउट बता चुका हूँ, मैं इस वक्त उस क्वेश्चन को एड्रेस कर रहा हूँ जो ये आया था कि जी एग्जिस्टिंग लॉ, बिकॉज 56 के रूल्स एग्जिस्टिंग लॉ हैं एंड 191 के नीचे वो लॉ की उसमें आ जाएंगे, एंड देयरफॉर जो हमने सुप्रीम कोर्ट ने रूल्स बनाए हैं, they are perfectly all right, they could only be
Mr. Attorney General, if I have understood you correctly, you say the term law used in Article 191 does not include the 1956 rules.
Cannot include 1950 rules as existing law,
No, but my question to you is, are the Supreme Court rules 1980 currently framed, are they law?
No, not within the meaning of 191, no.
Ji?
Not within the meaning of 191. And let me please try to explain it.
I'm saying,
इसको explain कर लेने दे ताकि at least वो question address हो जाए.
नहीं,
mean,
but
obviously
one
the
word
argument-
answer is no, they are not law.
They cannot be treated as,
obviously
they
they're
cannot
not
be
law
treated.
within the meaning of 191 because otherwise the argument is circular. How can this,
Yes,
I mean,
yes, my lord is right.
but
My lord can complete what
leaving
he is
that
saying.
aside,
Yes,
no,
that's
no,
right.
leaving that aside, I'm still curious. Are the rules, forget 190, the use of word law in 191. My question is more general. Are the Supreme Court rules 1980 law or not?
Supreme Court rules 1980 regulating practice and procedure cannot be called law within the meaning of 191. So to
But
that extent,
isn't
I'm
it
saying.
law
That doesn't
under
answer
the
my question.
constitution?
That doesn't
Under
answer
the constitution say ye nahi, says na by or under the constitution. This is something mandated under the constitution. It
Mujhe-
derives its.
Are your rules of, no, no, are your rules of business made under Article 99, are they law?
मुझे एक चीज
हाँ मुझे बताइए
मुझे एक चीज
अरे अटॉर्नी जनरल साहब
एक
you have
चीज
made
जरा
a
मुझे
very
address कर लेने दें।
extraordinary statement which are the rules of business made under Article 99 law or not?
My lord, my submission is that in the
Give me a
broader
straight
sense,
answer
in
to
a
your-
broader sense, yes, they would be, they would have the
Are the-
meaning
are
of
the
law for the
rules-
purposes of regulating
Are
the
the
business of
rules
federal
of the
government. Yes.
are the
Yes,
rules
yes,
of the
yes.
National Assembly rules of
Yes.
procedure made
Yes.
under Article
Yes,
60?
my answer to your question was that for the purposes of 191,
That
they
was
cannot be called.
But that was not my question.
Generally speaking, yes.
Vakil Saab, that was not my question.
Sir, मैंने कहा generally speaking, yes.
Generally
That's my
speaking,
answer.
नहीं, एक
But-
generic question आपसे
मैं अभी तो एड्रेस कर रहा हूँ और चीज अभी मैं एड्रेस ही और चीज कर रहा हूँ अब आप उसको और
कॉन्स्टिट्यूशन
से जाएं।
ने लॉ रूल मेकिंग पावर दी है एग्जीक्यूटिव को भी, लेजिस्लेचर को भी, सुप्रीम कोर्ट को। सवाल ये है जो एग्जीक्यूटिव ने अपने रूल्स ऑफ बिजनेस बनाए हैं इन एक्सरसाइज ऑफ पावर्स अंडर द कॉन्स्टिट्यूशन, आर दे लॉ?
Yes.
यस।
Was there a law?
जो लेजिस्लेचर ने अपने रूल्स ऑफ बिजनेस बनाए हैं, आर दे लॉ? If they are law, then why are the rules of business, framed by the Supreme Court in exercise of powers granted by the Constitution, the same powers which the legislature has, the same powers which has the executive has, not law?
इसी को ही मैं एड्रेस करना चाह रहा
जी करें।
आपने कहा कि जो हमारे रूल्स थे 1956 के
56 को जो 80 की बात कर रहे हैं,
उसको नहीं उसको अगर हम एक तरफ रख दें तो
Learned-
एटलीस्ट वी कैन
learned
एड्रेस वी कैन
attorney
टेक I need not make any further submissions on them being existing law and thus the term law including those meaning those 1956 rules. If that is accepted, I need not make
No,
any submissions.
I'm not accepting. What I'm saying is, आप 80 के rules की बात करें, वो law हैं या नहीं है?
नहीं, मुझे आप पहले वो एड्रेस तो करने दें अब आप उसको एक्सेप्ट नहीं कर रहे मुझे फिर सबमिशन उस पर कंप्लीट तो करने दें
If I've understood you correctly, you say 1980 के जो rules हैं वो under the term law आते हैं. However, in the context of 191, you cannot consider them as law because then the entire
Contradiction
process,
है.
then there will be contradiction within the letter of Article 181.
Absolutely.
ठीक है?
Absolutely, my lord. And यही contradiction है जो उस argument में है या उस point में है कि जी वो because existing laws में आते
नहीं,
थे
but वकील
क्योंकि
साहब, एक जरा kindly, Attorney General sir, you're making, speaking for myself, an extraordinary submission, so I want to be sure I understand. Now, you say 1956 rules are not existing law, but you say that the Supreme Court rules of 1980
no.
are law in the broader sense of the term, right?
Please rephrase me. Let me rephrase myself. What I said was that they would be existing laws. They would be existing laws covered under 268(7), but they can be termed or treated as law within the meaning of term law used in 191. That's what I'm
मैं
saying.
समझ गया हूँ बात, but still the reason I'm asking this question is that Rule 1, sub-rule 2 of the Supreme Court rules, which you say is law, specifically says the Supreme Court rules 1956 are hereby revoked.
Yes.
So both have to be law. Both have to be law. Otherwise, in 1980, the Supreme Court could have said there are no laws. There is the Supreme Court rules of 1956 never existed. They ceased to exist when this Constitution came into being. We don't need to revoke them.
So what
अरे
then this
बात
means
तो-
is,
अरे,
मैं
I
आपकी
need
बात
to
तो समझ
understand.
गया हूँ, but
नहीं, आप मेरी सबमिशन तो जो आप फरमा रहे हैं मैं उसको समझने की कोशिश
जी
कर
मैं ये कह रहा हूँ,
अरे बात तो सुन लेना। आपने जो आर्टिकल 268 पढ़ा, that says subject to constitution.
and
So it is possible, is it not, that the 1956 rules were existing law,
yes,
but the power to amend existing law within the meaning of clause 1, article 268 was subject to the constitution. The rules of 1956 were the rules applied in terms of the rule-making power, not law, rule-making power of article 191, and therefore the same shouldn't say problem, issue I would say, in relation to any legislation affecting, amending, restricting, repealing, whatever, the 1956 rules applied as it does now in the context of this proposition before us, this act versus the 1980 rules, exactly the same position applied. Would you agree with that?
yes, yes,
Yes.
yes.
Thank you.
And that is why,
Thank you.
that is why I would just conclude by this submission by saying that when existing
आपने
laws
जो पूरा
but
अपना
cannot-
बहस आपने जो पूरी अपनी बहस शुरू की है वो आपने किसी और बेसिस पे शुरू किया आप अपने आर्गुमेंट्स करते तो ये सारे मसले आपके लिए खड़े नहीं होते but
I am just
sometimes it is not very easy to give a yes no answer. It
What
was
I'm just saying
it was like the young on a lighter note माहौल भी जरा ठंडा रखते हैं.
अच्छी बात है.
On a lighter note, a lawyer was battering a lady during cross-examination. The husband representing the lady, and he said, "Have you stopped beating your wife? Answer yes or no." So keep things light and move ahead.
So I'll just conclude this submission by saying that the 1980 rules or the 1956 rules, though they were existing laws when the Constitution came in, but saying that they were the law within the meaning of Article 191 would be a contradiction.
Okay, can I ask a
And
question?
आगे चलता हूँ.
ये एक सवाल सुन लें कि आप ये कह रहे हैं कि वैसे तो the rules are law, but for the purposes of 191 they are not law. Now wherever the word law has been used, what principle of interpretation will be applied to see whether these rules or any other rules will be applicable there in the term law or not? The reason I ask this question is that the first day, my question to you was that if subject to the Constitution and the law meant law just an act of Parliament to the exclusion of everything else, then maybe the word law was not the right word. So when we look at the word law, we have to read something more than just an act of Parliament. So the act of Parliament is there, but other things are there. Now you are saying उसमें से आप ये rules निकाल लें because यहाँ rules नहीं apply होंगे. Then in some other provision rules डाल दें because वहाँ rules apply होंगे. So there doesn't appear to be any principle of law that one is following on the basis of which one would determine where to use what part of law.
इसमें learned Attorney General, since this discussion is in the context of Article 191, can we construe Article 191 that the rules may be made by the Supreme Court subject to the rules that it will make? This is the simple question.
फिर
You
इसमें
see,
एक बात
it
और भी है
automatically excludes the rules that will be made.
My Lord Justice,
Because it is in the
Justice
context
Afridi
of
made an
Article
observation and
इसमें
that
एक
sums it
बात
up.
एजी साहब और भी है, what I understand from the questions of the learned colleagues, that is subject to the constitution and law. Obviously, the Supreme Court may make the rules. Once the rules have been framed, and maybe this may be included in the definition of law, but whether there is any sunset clause after making rules by the Supreme Court, the word law has become redundant. Is the purpose then? If we are talking on it, then once the Supreme Court has made the rules, that has become the end of the story, and they cannot make further rules.
Attributing redundancy.
And the redundancy attribute हो रही है ना, अगर हम उसको करते हैं कि Supreme Court rule बना सकता है. Supreme Court has made up the rules. Then what is the purpose of the law used in the Article 191? Because there is no sunset clause. After making rules, obviously it will be a sunset clause for that. जैसे आपने नीचे पढ़ा है ना कि वो हाई कोर्ट के लिए उसकी प्रेसिडेंट साहब नहीं करते तो वहाँ sunset clause है. Unless such time the president make the rules.
So as I see it, the word law is evergreen in 191, and secondly, it might entail other instruments, but what I'm concerned with right now is the Act of the Parliament is also there, and that is enough for me to go forward.
Oh, yes, so.
Are you going to answer my question? क्योंकि वो तो रह गया.
According to
I
you,
owe an answer to a lady.
according to you, once the rules have been framed, in exercise of constitutional jurisdiction that 191 confers, they are law. Number one. Number two, because of the language of 191, it is an exclusive power given to the Supreme Court rules.
Where does the
Subject to the Supreme Court may make framed rules. So the Supreme Court framed rules.
and subject to the law and the
So,
Constitution?
what you're saying is, once this law has been made or framed by the Supreme Court, can a subsequent act of the Parliament trump it, or modify it, or render it redundant?